changes. Pursuant to notice, I call up H.R. 2189, the Law-Enforcement Innovate to De-Escalate Act of 2025 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 2189 to modernize federal firearms laws to
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chairman. The Gun Control Act, GCA, of 1968 was enacted to assist law enforcement in their fight against violent crime. Along with imposing stricter licensing and regulation of the firearms industry, the GCA also established a new definition of a firearm, which, according to the bill, includes, quote, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. While that definition has been suitable to the firearms industry for the last 57 years, modern advancement in less than lethal technologies, such as tasers, have created a need for Congress to take a second look at the definition to ensure the GCA, as written, does not stifle innovation. It is also important in promoting transparency during law enforcement encounters. For example, if a less than lethal weapon, such as a taser, uses an explosive propellant to fire its projectile, which in the case of a taser is its barbs, it would be classified as a firearm, despite its low probability of serious injury or death. And because that weapon is considered a firearm, if used during a law enforcement encounter, that use may be considered deadly force in 43 states across this country. This includes my own state of Wisconsin, which includes in its definition of deadly force the discharge of a firearm. It is an unintended consequence of a law passed long before advancements in less than lethal technologies that has led to fewer law enforcement agencies adopting more innovative tools due to their same classifications and restrictions as other firearms. Law enforcement agencies agree, and so do I, and so I would ask that the following letters of support be included in the record.
Without objection.
First, a letter of support from the International Union of Police Associations dated March 14, 2025, a letter of support from the Hispanic American Police Command Officers Association dated April 18, 2025, a letter of support from the Major County Sheriff's Association dated April 30th, 2025, a letter of support from the National Organization of Black Law Enforcement Executives, or NOBLE as it's called, dated May 23rd, 2025, and a letter of support from the National Fraternal Order of Police dated May 30th, 2025. These letters all agree that this change not only encourages more innovation within the less than lethal weapon space, but also promotes de-escalation during law enforcement encounters. In closing, I'd like to acknowledge that last Congress, some of my colleagues on the other side of the aisle took issue with certain aspects of the bill, including what they described as an overbroad exemption under the Gun Control Act. To those colleagues, I have taken your concerns seriously, and this bill has been revised to ensure the term less than lethal projectile device does not unintentionally carve out devices that could somehow be converted to handguns, rifles, or other firearms. The revised language in H.R. 2189 would no longer allow devices to be exempt under the CGA if the device is intended to expel or could be readily converted to accept or discharge firearm ammunition. This is in addition to the previous requirement that the device not exceed a velocity of 500 feet per second, and that it not be designed or intended to be used in a manner likely to cause death or serious bodily injury. I believe this tighter language will address any concerns of firearms being quote-unquote deregulated through this conversion to a less lethal device. I urge and hope that you can support this bill as revised, and I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
Mr. Chairman, thank you very much. Unfortunately, I have to oppose my friend's legislation, which I still think would create a dangerous loophole in the Gun Control Act by exempting so-called less than lethal devices from laws requiring firearms to be traceable, detectable by security equipment, and not available to prohibited purchasers like felons. This new loophole would allow felons and other dangerous people to more easily access weapons without a background check that are untraceable and undetectable. This legislation does real damage by rewiring the definition of firearm throughout the entire criminal code to exclude certain, quote, less than lethal weapons, which may not be lethal but are still highly dangerous, such as taser guns, which have been identified as a contributing factor in more than 500 deaths in the United States. Because the definition of what constitutes a firearm is central to our federal firearm legal architecture, altering that definition is a dangerous and complicated endeavor and will have consequences that perhaps are not intended by the bill's proponents. The bill defines a new category of weapon, these so-called less than lethal projectile devices, and exempts them, which are currently classified as firearms, from all regulation under federal firearms laws such as the Gun Control Act. And these weapons, contrary to what the title of the bill might invite us to believe, would be exempted from federal firearms laws regardless of who uses, purchases, possesses, or manufactures them, creating an entirely new loophole in our nation's gun safety laws. For example, if enacted, this bill would allow persons who are not legally allowed to possess firearms, like domestic abusers and convicted felons, to legally purchase these dangerous weapons that are still designed to incapacitate and overpower their targets. The loophole created would not only allow domestic abusers and convicted felons, for example, to buy these weapons, but allow them to buy them without any background check at all. It would exempt them from the requirement that they have a serial number and are traceable so that law enforcement can identify their owners when they're used in violent crimes. It would also exempt them from laws requiring firearms to be detectable by metal detectors and the X-ray machines used at airports. If H.R. 2189 were to become law, nothing would stop a convicted felon from purchasing a taser designed to avoid detection and carrying that weapon past security onto a plane, into a school, or indeed into this building. This bill would make all of us a little bit less safe. Supporters of the bill argue that it's needed to update the Gun Control Act of 1968 to reflect modern technology and ensure that law enforcement can use these less than lethal weapons, but law enforcement agencies are already exempt from many provisions of the Gun Control Act, and law enforcement officers have long used so-called less than lethal weapons in the line of duty. Supporters also argued the change is needed because the classification of these weapons as firearms may result in the use of the weapon being considered deadly force, even though the device is designed to be less than lethal. But federal courts have distinguished between deadly force and intermediate force in cases involving law enforcement uses of less than lethal weapons, and states are more than capable of modifying their laws to account for these technologies if they believe that they should do so. There is no indication that state or federal law is out of step with the design and use of these weapons, much less that such a mismatch has prevented law enforcement agencies from adopting them. Organizations working to end gun violence, including Giffords, Brady, Everytown for Gun Safety, and the Community Justice Action Fund, all strongly oppose this legislation. But it's my understanding that these groups have offered to work with the proponents of H.R. 2189 to try to craft narrower language to advance the legitimate stated purposes of the bill. If the purpose of the legislation is really to help law enforcement agencies access less than lethal weapons, then we can help you achieve that goal in a way that mitigates the dangerous consequences of the bill as currently drafted. The gun safety groups proposed alternative language that would define so-called less than lethal devices and exempt them from being classified as a firearm under federal law when they are used by a law enforcement officer acting in their official capacity. Although none of these gun violence prevention groups favor changing the federal definition of firearm, they're willing to compromise to ensure that law enforcement officers are not somehow prevented from using these devices while also mitigating the potentially dangerous consequences of this bill. So we really should keep working on this in good faith. But as it stands, I do not believe we can risk creating a new dangerous loophole in our firearms laws, and I yield back the balance.
Gentleman yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from Wisconsin to offer an amendment in the nature of a substitute.
Mr. Chairman, I do have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute be considered as read and shall be considered base text for the purpose of amendment. The chair now recognizes the gentleman from Wisconsin to explain the amendment.
Yeah, this amendment simply removes the year 2025 from the title of the bill. In no way changes or alters the purpose of the bill. And I would hope that you would support the amendment.
Is there any discussion on the amendment in the nature of a substitute? Gentleman from California is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
The gentleman is recognized under the 5-minute rule.
Thank you. First of all, I thank my colleague, Mr. Fitzgerald, for leading this bill. I just want to make a couple of important points. First of all, tasers save lives. The goals of using a taser is to reduce fatal encounters. The bill will also improve community trust by reducing injuries in the community when we have encounters. Clear classification standards and better recorded use of force events is also part of this legislation. Give you an example. When public safety officers pull a taser out of their holster, automatically a body camera will be triggered. If it's not an officer, it's an officer, an individual out in a community discharging a taser, that taser will automatically modify the cloud of the time, date, and place of discharge. You don't have that technology right now. This bill will also enable other public safety groups to have the access to tasers. How? By clarifying current law that essentially has resulted in vague classifications of firearms. The vagueness has resulted in essentially issues of liability. Many police departments today don't use tasers, such as the Dallas Police Department, because of liability concerns. And many groups right now are prohibited from having firearms and therefore cannot use Taser 10. Some of these examples are tribal governments, correction officers, and emergency room security officers. Folks, we have to benefit, we have to harness all the benefits of the new technology behind us while maintaining strong guardrails to assure that we're moving ahead when it comes to public safety. This bill tightens definitions, clarifies conversion limits, and enhances Department of Justice oversight, along with a five-part test to make sure that these Taser 10s qualify. This bill, as Mr. Fitzgerald said, is stronger than last year's because we listened to both law enforcement and reform advocates. A minute ago, my colleague was talking about loopholes. Let me be clear. This legislation does not supersede any local state laws. Furthermore, this legislation does not prohibit individuals already barred from possessing firearms or ammunitions under 18 U.S.C. subsection 922G from having the ability to have these weapons. In other words, anybody who's barred right now, a felon from having these weapons, continues to be barred from having these weapons at their disposal. Chairman, I also want to recognize at this point members of our community who have come here in support of this legislation. I'd like you to ask you to please raise your hands, please. I spoke to these individuals before the hearing, and all of them have personal stories about tasers and how less than lethal force could have had different outcomes when it came to their personal stories. Thank you for being here today. Thank you for being part of this legislative process. And Mr. Chairman, with that, again, I repeat my strong support for this legislation. Thank you very much.
Gentleman yields back. Is there further discussion? Mr. Nails.
Yes, sir. Thank you, Mr. Chairman. Mr. Correa, well said, all of it. Everything you said, you are on target today, and I appreciate it. I'm an old law dog myself, old sheriff. What you said today was right on target. Thank you, ladies, for being here. Thank you. Also like to thank my good friend, Mr. Fitzgerald, for introducing H.R. 2189, the Law-Enforcement Innovate to De-escalate Act of 2025. This bill will establish a new less lethal category in law to prevent new tasers, models, and other less lethal devices from being improperly classified as firearms. It's less than lethal, folks. The new statute will provide police officers better tools in their day-to-day operation and provides congressional direction to the Department of Treasury and Department of Justice on a clear multi-pronged process for classifying less lethal devices. Importantly, this legislation clearly outlines that only less lethal devices qualify and screens out any devices not intended to be less lethal in support of the law enforcement mission with that 5-part test, as Mr. Correa spoke about. As a former law enforcement official, I understand firsthand the crucial role that non-lethal devices play in protecting both law enforcement officers and civilians by providing officers with the alternatives to deadly force when confronting physical threats. By allowing officers to subdue suspects without resorting to lethal measures, these devices help minimize the risk to humans to all parties involved. Officers need resources they need to perform their duties safely and effectively. Investing in new technologies, such as non-lethal devices, is essential to achieving better outcomes and enhancing public safety. This legislation, folks, it will save lives, positively impact communities, law enforcement, prisons, and healthcare facilities seeking more or less lethal capability. I urge my colleagues to support this bill, and with that, I yield back.
Gentleman yields back. Chair recognizes Mr. Raskin for a unanimous consent request.
Thank you very much, Mr. Chairman. This one is an article published by ABC entitled, "An estimated 500 people have died from police use of tasers nationwide between 2010 and 2021.
Without objection.
A second is a letter from Brady Community Justice Action Fund, Everytown for Gun Safety in Giffords, opposing H.R. 2189.
Without objection.
And finally, a letter from Catholics for Family Peace, Jewish Women International, Illinois Accountability Initiative, Just Solutions, Legal Momentum, and the National Domestic Violence Hotline, explaining that H.R. 2189 would undermine laws designed to keep weapons out of the hands of domestic abusers.
Without objection.
Mr.
Is
Chairman.
there further discussion on the amendment in nature of a substitute? Ms. McBath.
Thank you, Mr. Chair. And I'm truly very, very grateful to all of my colleagues on both sides of the aisle for trying to collaborate to come to some consensus and trying to save lives and keep our community safe. And to those ladies and gentlemen that are here today, I'm really sorry that you have to be here. Thank you for being here to support this piece of legislation, but I'm sorry that you have to be here. I, too, have lost a loved one to gun violence, and so I take what we're saying here and doing here very, very seriously. But law enforcement officers serve as frontline support for every community, protecting, assisting, and ensuring public safety. That is why we must give them the tools to do that job effectively and safely. It simply does not make sense that we are considering a bill today that, in its true form, would put officers in great danger. Under current law, departments can already purchase a wide range of tools, including traditional firearms and so-called less-than-lethal weapons. And officers are trained to use tactics that prioritizes alternatives to deadly force. We must continue providing those resources and support that strengthens officers and community safety, not undermine them. This legislation was deemed dangerous nearly 3 years ago by the Department of Justice after review from prosecutors in the Criminal Division, the Executive Office for U.S. Attorneys, and firearms experts at the Bureau of Alcohol, Tobacco, and Firearms and Explosives. All agreed that this bill would endanger officers and communities by, and I'm quoting, weakening their efforts to keep weapons out of the hands of dangerous persons, end quote. The so-called Innovate to De-escalate Act would, in reality, escalate the number of dangerous individuals who would be given a green light to legally purchase and possess hazardous weapons despite clear evidence that they should be excluded. As the ATF warned, and I'm quoting again, these weapons could be used against law enforcement, security personnel, or the public, creating an increased risk of harm to public safety. They also would not be traceable if they were used in a crime, unquote. We rely on law enforcement officers every single day. They put their own safety and well-being on the line for us. Why then are we considering a bill that would expose them to even greater danger? It suggests that those voting for this bill are prioritizing increased profits for companies, including one that openly told investigators this legislation would, and I'm quoting again, open new markets over the safety of the people who protect us. This bill has been deeply problematic for years, yet this committee continues to push for its passage. When the very agencies that work directly with law enforcement and prosecute criminals warns that this legislation needs significant work, we should take the reasonable and responsible steps of listening to them and working and massaging the bill until it's at a place and juncture where it makes sense and there's safety for everyone involved. We should strengthen this bill so that it actually protects our officers and our communities and the people that live in these communities, and it truly serves as a tool for de-escalation. Gun violence prevention groups worked in good faith to find a way to address the supposed need for this bill. They worked on this. They've all collaborated together while ensuring it does not subject law enforcement or people in the public to unnecessary risks. As a mother who lost her own son to gun violence, I understand. I understand exactly how you feel and where you are, but we have to make sure that we're putting forth legislation that really makes sure that it's protecting people in our community and protecting law enforcement as well. So I urge my colleagues to vote no on this bill and to call the sponsors of this bill to commit to improving the legislation. I will work with you to improve it so that we don't jeopardize the safety of our communities with this bill in the present form. Mr. Chairman, I have a unanimous consent request. I request unanimous consent to submit into the record a letter from Sandy Hook Promise in opposition to H.R. 2189.
Without objection. And the
And I thank you.
gentlelady's time has expired. Is there further discussion? Mr. Biggs.
Thank you, Mr. Chairman. I support the underlying bill, and I appreciate what Mr. Correa said. Spot on today, sir. You never thought you'd hear that from me, did you?
I did not.
I'm in total agreement with you, but let's consider this. The bill does not change any state-level restrictions. It just doesn't. So, state across the political spectrum, you got California, Florida, Pennsylvania, Wisconsin. They already define less lethal devices. They restrict possession by convicted felons and certain violent offenders and establish criminal penalties for misuse. For example, in Florida, using a taser against a police officer or during a felony is a serious criminal offense. This is an instrument that actually saves lives. Every year, there are more than 1,000 people who are shot and killed by police officers. More than 1,000. That does not include those who are shot and wounded by that lethal force. But when you use a less lethal force, everyone is safer. Everyone will be safer. This bill is supported by 90 bipartisan co-sponsors, so we've from 35 different states, the Fraternal Order of Police, major county sheriffs, National Organization of Black Law Enforcement Executives, Hispanic American Police Command Officers Association, and Peace Officers Research Association of California all support this bill. The African American Mayors Association, the Next Generation Alumni Leadership Council, Prince Jones Jr. Foundation, Coalition of Moms Against Police Brutality all support this bill. This is a bill that will save lives. And I can't say it any better than what Mr. Correa said. And so I'm not going to belabor the point other than ask that these documents I have, Law-Enforcement Innovate, the De-Escalate Act, and Consumer and Law Enforcement Challenges, if they can be admitted to the record.
Without objection?
And I would urge everyone on this committee to actually, if you want to save lives, this is a bill you should be supporting. And with that, Mr. Chairman, I'll yield back.
Gentleman yields back. Is there further discussion? Mr. Johnson.
Thank you, Mr. Chairman. I rise in opposition to this legislation. It opens the floodgates for what's called non-lethal weapons to be sold on the streets of America with promiscuity. Everyone would be able to purchase one. And these non-lethal weapons are very serious in terms of the impact that they have on a human being. When you fire a not a projectile, but a dart or whatever they call it, into a person, then you immobilize that person. And you're able to do to that person whatever you want to do to them while they are under your spell, under the influence of that electrical charge. And so that means that if that person against whom this charge is used is armed with a traditional firearm, is that person, if I see you coming at me with an advanced taser, am I able to defend myself with lethal force to prevent you from immobilizing me and then doing whatever you want with me? So, it's going to make us less safe for these weapons to be in the hands of everybody. And let's face it, law enforcement officers, law enforcement agencies are not barred from having these new style tasers. They can buy them. You got thousands sold to law enforcement agencies. Tens of thousands of these are in the hands of law enforcement to actually want to change the Gun Control Act to make it easier for law enforcement to purchase these weapons. That's not what this legislation will do. This legislation will open the floodgates so that these non-lethal weapons can be sold to everybody. Anybody would be able to get it. A child molester, a convicted, aggravated sexual predator, anybody, a felon, any felon would be able to purchase this weapon. Anybody would have it, and it would have no serial numbers on it. It's untraceable. This is a step in the wrong direction. We should be trying to make the streets more safe than less safe. I support all law enforcement personnel having these tasers, these newly developed tasers. We need to make them broadly accessible. If finance is a problem, then maybe the federal government should help local law enforcement agencies to procure these weapons. It's in the public interest because I'd rather see a trained law enforcement officer using the taser instead of resorting to his traditional firearm, which is deadly. I certainly want them to have the option of less deadly force. But again, that's not what this legislation does. This legislation creates a loophole in the Firearms Act so that these non-lethal weapons can be sold to anybody, and they would be untraceable, and they would fall into the hands of minors. Anybody who wanted one could get one. And so we don't need to go down this route. I urge my colleagues to vote against this legislation, and with that, I yield back.
Gentleman yields back. Chair recognizes Mr. Correa for a unanimous consent request.
Thank you, Mr. Chairman. Unanimous consent to submit for the record a letter of support from our colleague, Benny Thompson.
Without objection. Is there
Chairman, I'll strike the last word.
wait. Further discussion, Mr. Fitzgerald.
I just want to talk about a couple of the comments that were made. Because if I'm understanding some of my colleagues, these are arguments that we've heard before. It's kind of the argument that the unknown is the scary part of this. But in reality, consumer tasers represent just a small fraction of all tasers that are available, less than 1%. And even if you assume that somehow there'd be this consumer demand, there is an increase in the amount of states that have been watching this and have been enacting bills at both the state and local level that govern the use of less lethal devices. Many states already have age requirements for purchasing the devices as well. California, I think, Florida was brought up, Pennsylvania, my own state, Wisconsin, they already restrict possession and use by convicted felons and violent offenders. So that's another situation that I just don't see that emerging at all. And they also have established, many states have established criminal penalties for misuse. So, you know, I still think that at the end of the day, it's about law enforcement. It's about a new technology that is available now. And if we are going to make this move, then I think certainly you can have added debate and discussion about it, but at the end of the day, this is a bill that ultimately will save lives. And even if you're completely in favor of some type of gun control, this is an alternative that I think makes sense, and we should pass it in the Judiciary Committee today.
Does the gentleman yield?
I do. I yield.
Mr. Fitzgerald, I just want to state for the viewers that there's a very strong element of the crowd that is nodding in agreement with what you're saying, and I'm curious, do you know any of their stories or why they're supportive of this measure?
Actually, in the entire time that we've been working on the bill, I mean, some of the greatest supporters of this legislation are those that have been directly affected by some type of gun violence situation in their own life. And I've met with many of them over the last couple of years, and the stories are often similar, and that is, you know, if somehow there was an alternative to what was available to law enforcement, there may have been a different outcome. And it's always hard to kind of project on that, but I think that is something that's a common thread amongst everybody.
It's just noteworthy, and I'll address Mr. Correa as well, that for the time of day to have this amount of support, all in agreement with what you all are saying, is noteworthy, and it's not being conveyed to the cameras, but I did want to note it for the record, and I yield back.
Gentleman yields back. Is there further discussion? Mr. Garcia.
Thank you, Chairman. And to the sponsor of the bill and the advocates who are present here today, had a chance to meet with you outside and have a conversation. I truly understand your motivation, and individuals, loved ones who you have lost due to the use of deadly force by police officers. And I know that what you're looking for is a better alternative. And some of the arguments that have been advanced seem to make common sense, but I believe that the advancements and the promise in the technology are still not convincing enough for me, someone who wants to see a breakthrough in the number of cases where lethal force is used by police departments, and where in places like Chicago results in astronomical amounts of money being paid out to the families of victims who have been killed or severely injured by police officers. So I share that because the motivation of the advocates is very noble. You've seen, you have felt, and you're aware of dynamics in your communities, and you believe that this is an alternative. But I think some of the arguments and the evidence that's been submitted thus far gives us good reason for additional pause. I think that you may be on to something. I think that the technology is advancing and evolving, but I'm not at that point where I can be supportive. I tell you this in all sincerity as someone who has led efforts in my community prior to coming to Congress in the area of violence prevention and intervention. So I truly care about public safety and community safety as well. And I know that it takes a lot to come to a place like Washington, to come to this committee hearing, to wait for hours for an opportunity for a cause, an issue to be heard. And I'm truly grateful that you are here today because you are making us analyze, you're making us take stock, and you are raising our awareness on perhaps something that we need to be acting in the future. But at this moment, I am not yet convinced. I appreciate the sponsor. I appreciate that there is some level of bipartisan support. But at the same time, I had to chime in after listening careful to all the arguments that had been advanced.
Gentlemen, yield.
Yes, sir.
Thank you. I just want to remind folks that tasers today save lives. This technology improves the distance that a taser can be used. Okay? These guests that are here today have their personal stories of where a taser could have resulted in a different outcome. Their loved ones possibly still be with us. And they're here because they know this technology works. There's safeguards built into this legislation. 5-part test, plus approval from the DOJ. Felons cannot buy these weapons. This technology will save lives. And I ask my colleagues that are in opposition to take a few moments. Go look at the technology. Go test this for yourselves and make sure you understand what is really before us today. It's about minimizing, eliminating those ugly situations that happen between those in our communities that are challenged, that have mental issues, that have other challenges, and an officer possibly that comes to the scene and he's got to make a choice, lethal or non-lethal. This technology gives them another tool to go non-lethal. Remember that. Thank you, Mr. Chairman, and I yield.
Gentleman's time has expired. Is there further discussion? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. The ayes have it, and the bill is ordered.
Ask for a recorded vote, Mr. Chair.
Recorded votes requested. The clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock.
Aye.
Mr. McClintock votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Roy. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Klein. Mr. Klein votes aye. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes yes. Mr. Nels. Mr. Nels votes yes. Mr. Moore. Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Jordan? Mr. Jordan votes yes. Mr. Fry? Mr. Fry votes yes.
How is Mr. Nadler recorded?
Mr. Nadler is not recorded. Mr. Nadler votes no. Ms. Kamlager-Dove is not recorded. Ms. Kamlager-Dove votes no. Mr. Gill, you're not recorded. Mr. Gill votes yes.
Okay, clerk will report.
Mr. Chairman, there are 18 ayes and 8 noes.
The vote being 18 in the affirmative and 8 in the negative, the ayes have it. The motion is carried. The bill is ordered, reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill reported as a single amendment in the nature of a substitute incorporating all adopted amendments.